as questions pop up. So we're back, Senate Education, looking at S-120. Ms. St. James, if you would take us through, please, this new draft, which again was, my understanding was it was consensus language. It's not consensus language. That's fine. We will work off of this draft and see if we can identify the areas of disagreement and have those on the sidelines sort of jump in and help us so we can get to where we might find us might agree. So Ms. St. James.
Great, thank you. Beth St. James, Office of Legislative Counsel. So you should have two documents to work with. One is draft 1.1 of a committee strike all amendment to S-120 is introduced. And one is a side by side by side. And we're gonna
Impossible. 1.1. This is getting, at least for me right now, this is a little confusing.
Yeah, I'm getting there.
Okay,
We just give you a
okay, yeah,
little space. I promise I'm gonna bring it all
okay,
home.
Okay,
Okay. So draft 1.1.
Yeah.
There's a little key for you at the top. So section 1, highlighted in blue,
maybe
is
that's
not consensus language. It's as introduced.
right.
Okay. This section represents really, from the information that I have,
Mhm.
the only language that is not agreed upon yet. And the proposed language
Mhm.
for you all to consider was not my language that I drafted. Okay, so I did not offer it other than in this side by side,
Mhm.
so that you can see the section, well, yes. The section from the bill is introduced, which what's in draft 1.1. And then in the side by side, what I assumed would be happening is that the witnesses who were offering this non-consensus language would have that for you. And I added it to this side by side, kind of just as a demonstrative exhibit as you debate or deliberate. So section draft 1.1, section 1. We look at the key up top. This is the language is from the bill as introduced. You have starting on page 9 of the side by side, the proposed language that has not been agreed upon and is not in draft 1.1 because it is not agreed upon here. Section 2 on draft 1.1, page 3. It is my understanding from talking to Ms. Robinson, Sarah Robinson, that this is consensus language.
That is correct.
Okay. And we can see from the top changes from as introduced, right? Consensus language. You can also see column 2 in the side by side. If you go to page 12, there's that consensus language. Section 3 also consensus language is my understanding.
Correct.
The yellow highlighting represents changes from the bill as introduced. There is some language in here that is the same. And I wanted to make sure you understood that. So if the language is not highlighted, it means it's from the bill as introduced. Section 4, I believe, is consensus. There's no change there from the bill as introduced. Section.
Well, just so it says repeal.
Mhm.
Okay.
Yes, so the bill is introduced, we are repealing a repeal. So right now, the Intercollegiate Sexual Harm Prevention Council has a sunset baked into it, sunset on July 1, 2025. This language was in the bill as introduced, and it removes that sunset language. So it essentially creates the Intercollegiate Sexual Harm Prevention Council as a permanent fixture going forward. There's no repeal date. You could do anything you want here. You could keep the repeal date, you could change the sunset date, or you could, what this does, repeal the repeal and create this intercollegiate council in perpetuity until another legislature makes changes. Section 5, I believe, is consensus language.
Right.
And again, the only changes between the draft as introduced and this consensus language is this language on promoting training opportunities? I believe the bill as introduced was requiring something slightly different. And the side by side would show us that. Yep, it required them to create an annual conference to address the same things. And then the appropriation remains the same, and then the effective date, although I can see there's already a typo in there on page 4, page 6, line 4, I need to change that to fiscal year 2025. But the effective date is updated to 2025. So my understanding is the only language in draft 1.1 that does not represent consensus language is section 1. And if you have a witness who has offered you that language, great. Otherwise, you can find it on page 9, starting on page 9 of the side by side. Does that answer at least your questions of what's consensus and what's not?
Committee?
Yes.
Okay. So now let's go through the bill. And then we'll ask, just so we can all be reminded what's in here. And then when as we look at section 1 itself, we will go back to which page?
9.
Great. Okay. So section 1 as written right now,
In the draft 1.1
in draft 1.1, yep,
is from the bill as introduced.
right, and it does,
And this, what does it do? Oh, it requires post-secondary schools to maintain memorandums of understanding with their local sexual assault member organizations of the network. And then it requires the memorandum to contain certain things. Do you want to walk through all of those things?
looking for committee if you want to walk through. Nope, I think we're okay. So my question would be, normally, we do not call out an agency, and here we're calling out the network. Ms. Robinson, can you help me out with
Yes.
this? In legislation, wouldn't we want people to have different options?
Absolutely. And so that is why we have proposed the language that you will find on page 9 of the
Right,
side by side in formerly section 3, which is now section 1 of 1.1. And you will see that that language is revised to indicate that institutions of higher education shall ensure that students have access to confidential sexual misconduct support services. And in subsection B, we refer to external providers. We do not, we've removed all references to the Vermont Network or member organizations.
okay. That's really helpful. So again, so that takes care of that piece. And this is what you're all putting forward as your suggestion, but correct me if I'm wrong, UVM and others do not agree with this. Okay. May I, go ahead. No, go ahead, Ms. Robinson.
There is, my understanding is there is still not full agreement on subsection A.
Okay,
As proposed on page 9 of the side by side, and I can just tell you from our perspective, the important component of subsection A is ensuring that those support services are in accordance with 12 VSA 1614, which is our crisis worker privilege statute.
and so this would basically, institutions of higher education shall ensure students have access to confidential sexual misconduct support services covered by 12 VSA, either on campus or, that's what you're talking about.
That's
Okay.
correct.
And I'm wondering if we could, since this sounds like it's a point of disagreement, hear from people that are opposed to this. And why? Anybody?
Sure, I'll
Please,
start.
Ms. Cronin.
So, I will say that in our area of disagreement is only in subsection A. In
Okay.
subsection B, we are in agreement.
Okay.
I will also echo what Sarah said at the beginning, that I feel like we've made a lot of progress.
Yeah.
This is the only area that the university continues to have any disagreement with.
letter
This is
A.
it, letter
Okay.
A. And so here are our proposed changes, which I sent to Morgan also, so you have them written down.
Can you just first tell us just why you disagree?
Yes, well, let me tell you
Okay.
the language that we want to change and why. So the subsection A reads, institutions of higher education shall restrike the word ensure and use the word facilitate students' access to confidential sexual misconduct support services. And the reason why, and this I'm reading from what Jen Papillo, my colleague in the general counsel's office, is saying that we and others raised concern about the use of the word ensure. We had suggested, are made aware of, and referred to before, but that wasn't accepted. So we're using facilitate because we cannot require students to engage with any provider, even if we have an agreement with them. Whether a student engages with a provider is up to them. And so we feel that the word facilitate rather than ensure represents what we as an institution can do for students. The second difference in the sentence is that after we say support services covered by 12 VSA section 1614, we have included language that says or other legally recognized privilege of comparable effect either on campus or off campus. We have a concern that we have students that are not in Vermont. For example, we send students who are in our Larner College of Medicine to Connecticut and to sites in Maine for doing their clinical rotations. And we would like students to be able to use providers where they are when they are off of our campus in a program that we are running. And we would like we can't require that other states have our exact same language that we have in 12 VSA, but we are suggesting that they should have language that's comparable to our standards. The other piece is that this language, the language proposed by the network, does not allow us to create on-campus programs that would use somebody like, for example, a social worker as a counselor. Social workers have privilege. It's slightly different than what's in 12 VSA. So for us to rectify both of those things that we are concerned with, adding the words or other legally recognized privilege of comparable effect fixes that for the university. And I know that others may want to chime in on that, so.
Yeah, and I'm not an expert in language, but let's just take confidential sexual misconduct out. And I'm in no way making light, but let's say we said food. We would ensure students just access to food, access, just that it's there, seems to me to be like, okay, rather than facilitate. So I'm not sure how others are feeling, but the ensure isn't. Yeah, please.
Yeah, that was one of the points I wanted to raise. I do appreciate the second point, and I see where you're coming from with the other legally recognized privilege of comparable effect. That makes sense if a student is studying abroad or in another state.
Yeah.
But the first part, I don't. I mean, it's similar to what you were just saying. I mean, if ensuring access is available, I don't read that as compelling the university to require a student to participate in that support service. So, yeah, that's just how I'm reading it.
Ms. St. James, but by saying ensure, does it mean compelling or does it mean just ensuring access?
So I'm just looking, Morgan was kind enough to just send me the language, which is easier to digest in the written form rather than I would agree with the committee that institutions of higher education shall ensure students, the ensuring is the having access to. I would agree with that. I would agree with that. if that's all you want me to comment on.
That's what I need you to comment. Others that want to comment on that particular language. So I know there are witnesses,
I do. This is
Yeah,
Catherine
if you-
Santiago.
yeah, if you just introduce yourself.
Certainly, Catherine Santiago, Associate General Counsel for Vermont State Colleges. And so I echo the sentiments of everyone here in the appreciation of the collaborative efforts of getting this together. We do not support 3A as it was proposed. We also support the amendments that were just proposed by UVM. And so the challenge with the word access is that in discussions with stakeholders, it became apparent that everyone had a different perspective of what access meant. There were discussions that it meant something than making available and referring students. It felt as though the intent may be something different than connecting students. It would rather be mandating that connection. And so that became a focus on making that what access meant a bit clearer. So as it was worded to me, something more than a warm handoff. And so I'm not sure that that doesn't cross over into more than just merely providing access or a referral or a connection or an in-person connection. It seems something more than that. So I think the language of facilitate access helps illuminate what the idea and the intent of access would mean.
Any questions for Ms. Santiago before we move to Mr. Nolan? Mr. Nolan, do you have a comment on this section?
Thank you so much, Chair. I do not have a comment on this particular section.
So are you in agreement? Ms. Steigley, please.
I just want to, Susan Steigley with the Association of Vermont Independent Colleges. We support the position of the state colleges and UVM on the wording, facilitate, and also in particular, the other language after the 12 VSA. We have students who are abroad who are accessing other resources, SIT students are abroad, Middlebury students are abroad. We have students in other states too, so it would be problematic if that section ended after 12 VSA.
Bay State Colleges supports the amendments to Section B as well that were proposed by UVM. Excuse me, the second sentence, the second portion, other legally recognized confidentiality privilege providing comparable effect. That portion, if we support that as well, for the same reasons provided by Susan and UVM, which is we have out-of-state students who are either online for Vermont State Colleges. We have a large portion of online programs, specifically at CCV, but certainly at VTSU. And so those include many out-of-state students, as well as we have students who complete some of their programming requirements out of state and neighboring states. So we need the flexibility to be able to have providers who can provide comparable services, but maybe by the mere fact that they're out of state don't have the VSA 1614 designation.
Senator Hewitt.
Can we please hear from the network as to why they don't support the language that's being proposed for that section?
The facilitate?
No, sorry, the second.
Oh,
Or both.
yeah, Section A in general.
Yeah, so I can just share briefly that have access to or facilitate access to. Again, we do not believe that it at all requires access to. It just requires that there is the choice for students to engage in those services. I will say that the language that I just heard verbally, and I am reviewing as was submitted by Wendy Koenig in terms of comparable effect. Essentially, 12 VSA 1614 is our crisis worker privilege statute. It provides a very specific kind of confidentiality. And so that's very important. And so I would say that any organization or any crisis worker in Vermont can provide services to people who live in Vermont or don't live in Vermont. So essentially, all that this subsection A as proposed is doing is ensuring that institutions are providing access to students with confidential sexual misconduct support services. And, we just essentially are concerned about other forms of confidential services do not have the level of confidentiality that crisis worker privilege has. And for that reason, we feel like it's important to reference that statute.
So how do you sort of align with or your opinion on the abroad issue? I mean, that was one of the concerns. You have students, they're, might be doing a term abroad, there might be a campus abroad, all sorts of things. And how do you define legally off campus?
Yeah, I would say that it's, one of the things that the committee could consider would be to say that institutions of higher education shall ensure students have access to confidential sexual misconduct support services covered by 12 VSA 1614, period.
Right, because if you're off campus, you could be at home in Minnesota zooming
Absolutely.
in. Yeah.
Absolutely. And the intention here is simply for institutions to ensure that their students are aware of access to confidential advocates. And so, the same is true for any institutional service that's provided, essentially, is that students should be able to access that from wherever they are. So I personally don't feel like the on-campus, off-campus concern is one that that I'm overly concerned about, we should say.
Ms. Koenig.
I think the other problem is that what this effectively does, if you don't have that, is to say that
Don't have what?
if we don't have the language I'm including or other legally recognized privilege of comparable effect, it's saying that we must use local services only. And we would like to have the ability to use the services we want, whether they're national or whether they're local or whether they're international. And so limiting it to 12 VSA, I don't have any problem with having confidential crisis worker status, but we do not agree with being limited only to using services in Vermont, which is what that would effectively cause us to do.
Just to add to that, Susan Stidley with AVIC again. SIT and Middlebury have 24-hour international hotlines, confidential international hotlines that their students can access. They're not going to be able to access workers in Vermont 24/7 internationally on different time zones around the world.
Ms. Robinson, I have to be honest, it seems like it keeps kind of going back to the network that we're, at least, and again, help me, I could be completely wrong in reading this, but it seems like you want everything at the network. Is that, no, it's not accurate.
No, we simply want the advocates that are accessible by students to have crisis worker privilege. And, so I'm happy to look at the comparable effect. In our stakeholder conversations, one of the things that came up was some of the post-secondary institutions were saying, well, what if we want to provide social workers? Social workers do have confidentiality, but it's a different kind of confidentiality. And it's, okay. And so I'm happy to, again, work with Wendy and Catherine and others on the comparable effect. But we would want to ensure that when students access confidential resources, that they are indeed confidential.
Yeah. Anybody want to respond to that?
Well,
yeah, Senator Rashid, please.
So I guess my question would be then, let's say the language of where it says, or other legally recognized privilege of comparable effect, let's say that's not in there, and a student who is studying abroad in France on a program with the University from Vermont they're in a situation where they want to talk to a confidential, they want to have a confidential conversation with an advocate or somebody who can help them out. What would that be covered under? Actually, no, I'm not quite sure how to phrase my question. I'm still not understanding why this is a problem for the network, or rather you disagree with the language for the other recognized privileges of comparable effect.
Yeah, that would be helpful.
I'm happy to look at that language again. I will say that the example that was provided to us by the post-secondary institutions was about ensuring that the language would allow them to provide social workers to students or therapists, and social workers and therapists do not have comparable effect. So I would want to ensure that we are just clear on the intent and effect of that language. So I'm happy to, I can, today, work with Wendy and Catherine to just ensure that we can try to come to agreement on subsection A, but just ensure that we have agreement there.
And I also would like to be included in that because I have to agree as well. I want to agree.
Yeah. Skonik, I'm not reading a lot of confidence on your face. Tell me what your concern is.
I know that the concern that we expressed in this conversation that we were having and what Sarah is referring to is that if, let's say this example, if UVM ever decided that we wanted to create an on-campus program for sexual assault or support system,
Yeah,
if we wanted to employ anyone other than a confidential crisis worker in that program, if we wanted to have a therapist, if we wanted to have a social worker, we wouldn't be able to do that under this statute. We couldn't put that together on campus. It would have to be someone, a crisis worker privileged person only.
and
The
then
language
Robin,
is limiting.
please, what is the concern again with that?
So
That's
the
what I'm-
concern, the bar to be a crisis worker in Vermont is simply 20 hours of training under a certain type of supervision. So it is not it's not extensive, but it is specific. And what crisis worker privilege provides is that those advocates may be subpoenaed, but they have legal protection against subpoenas from being pulled into legal cases and testifying in cases that are related to the confidential services that they provide. And so what we would not want to do is create resources for students on campus where they believe they're accessing confidential services, but then the information that's shared with that advocate or support person is then able to be used against them in some kind of proceeding. And so what including 12 VSA 1614 does is ensure that that crisis worker privilege is intact for the support services that students are accessing.
Senator Sheen? Correct.
It's a tough one.
Yeah,
I'm
yeah.
reading 1614 and I like the language and it does seem to be, pretty watertight in terms of confidentiality. I am wondering how do you thread the needle with the kids or the folks who are abroad? I just don't understand how that works.
I can just say that, crisis workers in Vermont that work at various kinds of organizations provide 24 access to hotlines, chat lines, and lots of different advocacy that can be accessed both in person and remotely by people at all locations.
Quick statement or question, maybe. The comparable effects piece. I mean, I'm looking at the section, communicate, and one of the subsections is that communication is confidential if not intended to be disclosed to third persons. And then it goes on a bit further. And so as I'm reading legally recognized privilege of comparable effects, I mean, at first glance, I would interpret that as meaning that this same level of confidentiality would be applicable? Or is there something that I'm missing?
Yeah. Ms. Robinson.
I guess that's a question.
Yeah, it's
I
a
think
great
that's the
question.
intent. Yeah,
That would be our hope, and we could live with language like that. I would say the concern we have is that, as you know, you just heard from Ms. Koenig, you know, the examples that have been provided have been not related to people actually having the same level of confidentiality.
Ms. Koenig?
I think that our general counsel is concerned with two issues here, as I've stated. One is that if we have a student in Connecticut or a student in Maine who needs to have this kind of crisis worker to talk to, and they would like to do it in person, that they're able to do that in Maine or Connecticut
Right.
and not have to get on the phone or the computer and use that service if they're away. There's that. I think.
I mean, that to me, just stop there, that seems logical.
Yeah,
To me.
I think
If
that's.
you're in crisis or you wanna talk to somebody, get away, your local, even if it's your local therapist. You know, it seems to me that you don't wanna move, you wanna deal with it right there.
Yes, so I think that was the original auspice for putting that language in. I think our general counsel was also concerned that if we don't have that language in, that it also precludes institutions, the university and others, from having other types of services located on our campuses that we would like to put together. And if Sarah would like to talk to Jen and me about it further, I'm happy to do that. Jen could not be here today.
Sure.
But those are the two concerns, and we thought that this language covered both of them.
No, I mean, I was going to say it. At this moment, I'm fine with the second part of this, which is for other legally recognized privilege of comparable effect. I'm not fine with switching out ensure with facilitate. I don't think that ensuring that access is available is equivalent to the university is required or compelled to make a student participate in whatever the program or whatever therapy or access to a crisis worker. So yeah, I'm not sure of the need to change, to make that switch with ensure to facilitate.
Senator Williams, thoughts? Now, Senator Weeks.
I recognize a variety of opinions. I do believe the language that was offered by UVM seems satisfactory for taking care of the variety of scenarios encountered here.
Do you have specific thoughts on the ensure versus facilitate?
Facilitate's fine with me, and certainly the second part I fully understand.
The second part, certainly.
I would like to keep the language of ensure. I'm actually also fine with the way it is written here. There's nothing that would say to a student in Maine that they can't go see someone in person. I mean, this isn't saying that you cannot, see other kinds of therapists right? Am I missing something?
Ms. Koenig?
Well, if you read it on its face, that ensure access to confidential sexual misconduct support services covered by 12 VSA, section 1614, period. Without the other language, I think that does tell us that we have to have them talk to people that are covered under our state statute.
I see.
But
Yeah,
it doesn't say it has to be in person.
Right, but if they're in Connecticut
Connecticut.
and they're visiting a crisis worker in Connecticut, they are not covered by
So
Vermont
if they're in
statute.
Connecticut, I guess they would potentially have to make the choice to get this kind of protection over Zoom. Or another kind of protection, not on Zoom, in person, or they could do both.
I'm not sure. Please, Ms. Koenig, I think you'd have to actually, what I would like somebody to be able to do is if they're in a crisis in Connecticut, go to the closest person that they can feel comfortable with, access their therapist. That, I mean, that seems to me like the best thing for the kid.
Sure.
And right now, if we were to put a period, correct me if I'm wrong, after 4, then that would cut that off.
Could I add something?
1 second, I'm looking to Arledge Council since,
What is your question?
so,
I have a lot of thoughts.
yeah. And I'm sorry, I pulled you in a little bit more, but so the young person in Connecticut,
Mhm.
away from you know, or in another state. If we want that student to be able to access a local therapist, local crisis worker, you know, somebody. If there is a period after 4, does that prohibit that student from doing it? And after 4,
The number.
16, 4,
The number
14.
Oh,
I'm looking at Ms. Koenig's language.
I guess I don't understand your question. I don't read this language as limiting anyone to anything. I read this
And
language,
just so I know which language you're looking at.
either Ms. Koenig's, well, okay, I'm gonna look at page 9.
Okay,
I don't read this language as limiting any options. I read this language as requiring a post-secondary school in Vermont to ensure access to services that are covered under 12 VSA 1614.
Yeah.
And that those services could be rendered either on campus or off campus, period. But I do not read that language, and great minds can disagree.
sure.
To limit other options. I think you have a couple options here, and the one thing I will strongly encourage you to do is if you are contemplating the or other legally recognized privilege of comparable effect, I would encourage you to take some testimony on what those privileges what that might mean. Because I think 12 VSA 1614 is unique in that it not only covers the crisis worker themselves, but it covers the victim from being compelled to disclose information, which is different than the privilege between a doctor and a patient, or a social worker and a patient. That privilege is on the doctor or the social worker, right?
Yeah.
There's also, and the privilege that covers social workers and doctors, et cetera, some exemptions, the patient is. This is not my area of expertise. So if you are going to consider that language or continue to work on this, I would either encourage you to have me phone a friend and confirm my understanding, or have one of my colleagues come in and talk to you about those privileges.
Phone a friend is fine.
But, you know, I just don't see this language as limiting. Now, I think one of the pitches I make to the committees I appear in front of all the time in the education context is, that's nice that I think that, reading the black letter of the law, but you should really be concerned about what the field is going to do with that language. So if you are hearing from the field that they feel as though they are legally bound to offer no other options, which I just disagree with, you could certainly add language to clarify that, right? You could add language that's specific to out-of-state students or students who are studying abroad. You could go with UVM and BSC's suggestions. I think you have a breadth of options, but you all need to be clear on what your policy goals are here with this language. And if the policy goal is simply to require Vermont post-secondary schools to facilitate access to crisis workers, boom.
Ensure access, yeah, or whatever.
Counseling services
Yeah.
have the potential to be something different than just access to a crisis worker. So I think you need to be clear on what your policy goals are here. And then we can craft the language that meets those goals. I'm not sure you know what your policy goals are yet, based on this conversation.
Well, I think what we're trying to do is make it as easy for a young man or woman or a person to be able to access resources on this related to this issue, no matter where they are. And it sounds like,
What resource, I would say to you, what
Okay.
resources, right? Is it just the crisis worker resources, which is different than the resources potentially that you can get from seeking a psychiatrist?
right,
Or an advanced practice registered nurse, or
Yeah.
a social worker, or a psychologist, or someone who's on the roster. I mean, those folks all have different scopes of practice.
and different levels of confidentiality.
No, they're all
Okay.
covered under the same statute. They'd be considered mental health workers, but they all have different licensure and scopes of practice, which means they are able to do different things with you.
Yeah.
So again, when you say access to services, what services?
Senator Sheen.
Can we just say, to clarify, if the issue is clarity, can we just say that this section shall not prohibit post-secondary schools to from ensuring access to other services,
Support services.
support services?
Say that again for clarity.
Can we put another sentence in that says, nothing in this, in section A shall prohibit institutions of higher education from ensuring or facilitating access to other support services?
And keeping those support services being.
Whatever, the non-crisis workers, that the folks that fall under 1614.
That's problematic confidentiality, isn't it?
Well,
That's right, was this, St. James, is it a confidentiality issue that we're talking here?
I don't know. It depends on what your policy goal is. So if your policy goal is to ensure a certain level of confidentiality,
Yeah.
then you would need to explore what the different service providers, what confidentiality attaches to those services.
Uh-huh.
The crisis worker privilege, so doctors, nurses,
Apology.
it's the patient's privilege. It's 12 VSA 1612. They fit under one, and mental health professionals fit under one. And then the crisis worker is a separate privilege.
Yeah.
It's a little different there. The
Okay.
crisis worker is prohibited from sharing disclosures, but there's also a prohibition on the victim from compelling the victim to disclose information that they gave to a crisis worker. That is not the same privilege for medical professionals or mental health professionals.
Right.
I'm going to caveat that with,
Yeah,
I am your Title 16
yeah,
gal.
yeah, sure.
I am not your Title 12 gal. I do have litigation background, so I feel relatively comfortable
Mhm.
counseling you on that. But I would want to talk to Michelle, and either have her come in or just confirm that what I am telling you is not grossly negligent. And certainly if there are other lawyers here who disagree with me, I hope that they would speak up. So I would just say, again, it depends on your policy goals. If your policy goal is to require all post-secondary schools to ensure students have access, or to require schools to facilitate that access to crisis workers,
Mhm.
then I think you need to keep something close to what is in A on page 9. Whether that's ensure or facilitate, I think. I don't think that language prohibits it. I think Senator Hashim's suggestion of adding language in there that is making it clear that this language is not intended to prohibit a school from also offering other services. I don't think that takes away from the requirement to offer the first service. So if you want to make sure that both services can be offered, great. If you are only concerned about the crisis worker, then I don't think you need to add anything. But again, I always think it's important for you to hear from the field on how they would interpret that language. And making sure that you're not going to put out language that I'm the only person who thinks it works.
I think that was a time issue.
Yeah, no question. Senator
So I was
Shields.
just gonna mention, regarding the confidentiality piece, I mean, I know there's also, there could be different services that, yeah, I feel like a student, could potentially be in a situation where they don't want to see a crisis worker, maybe they just want to talk to a peer who had a similar experience, and obviously that wouldn't be confidential, but I think there should be a level of deference to the student in deciding what, do they want to talk to a crisis worker, where it'll be confidential, or do they want to talk to somebody who maybe had a similar experience, or I mean, I don't know what other types of non-confidential support services there are, but I mean, and then I also think there's the obvious level of responsibility that the schools have to make sure that the student knows, if you talk to this person, it's not confidential. If you talk to this other person, it is confidential. That there has to be that. Yeah, those are my things.
I think Senator She makes a great point around letting the student decide at that moment which direction they want to go in. They want to talk to somebody that is a crisis worker, they want to talk to somebody, their local count, I mean, depending on what they want to do with them. Ms. Robinson, you've heard the discussion and you're probably reading the committee a little bit. Do you think
Yes.
we get somewhere, or do you think this is pulled and we wait?
I think that you absolutely can get somewhere. On just listening to Senator Hashim's suggestion, I think that language could absolutely work. The intention was not for this, not to prohibit any other support services to be available. In fact, we encourage institutions to have a range of support services that are available and different types of professionals and supports accessible to students. This essentially just sets the floor. And so I think that recommendation, suggestion that was made by Senator Hashim, just to clarify that, would absolutely work for us.
Ms. Koenig?
I think that it has potential. I'll need to run it by my general counsel.
Okay. Ms. Steffi?
I would need to see it written out,
Yeah.
and think about it as well.
Okay. Ms. Colburn?
Thank you so much.
Yeah.
Helena Colburn, also from the Vermont Network. And yeah, I really just agree with my colleague and would just say, I think what I heard your legislative counsel say, and how I understand the language, and certainly the intent of the language, is there's nothing compelling the student to access those services. The language is just ensuring that access is there. That's our intent, I believe. I'll let my colleagues say if Sarah weigh in if she thinks I've misrepresented anything, but.
Drake, I'm forgetting your last name.
Turner.
Ms. Turner?
Yeah, Drake Turner from the Vermont State Colleges. I'll echo what Susan and Wendy said about taking a look at that language, and I can confer with Ms. Santiago as well.
Great, thank you. Mr. Nolan, you've been immensely patient with us. How would you like to weigh in on this work that's being done? And you know the points of agreement, and I believe you're representing AVIC?
Yeah.
That's right.
Yeah, just a brief introduction.
Yeah.
He works with many of our colleges. He also works across the country with colleges and universities on Title IX compliance and policies. So he's here just to talk about the amnesty provision.
Okay.
Why we think it's duplicative and not necessary, even though we're not opposing.
Even though you're not opposing. So just the amnesty piece, if you would, go ahead.
Sure. Thanks very much, Chair. I appreciate that. So just, can I give you like a 2-minute background on what I do?
Sure.
Okay. So I practiced at Dindsey in Vermont for 27 years. 2019, I moved to a national firm. My office is in Boston. I've worked on DOJ funded programs, Virginia DCJS, which is a Department of Criminal Justice Service programs, providing trauma-informed training through those. I've worked on the American Council on Education, which is sort of the Uber lobbying group for higher ed. You probably know that. They have task forces whenever the Department of Education goes, the two times that they've made substantial changes in regulations related to Title IX. I've worked on both of those task forces in 2020 and 2022. I've published for the National Association of College and University Attorneys on these issues. I'm admitted in 5 states, 4 of which have laws that, in my view, attempt to do some substantive things in areas that are covered by Title IX from a state perspective. So I have perspective on how that works. And my work on fair and equitable trauma-informed investigation programs was cited 6 or 7 times in the preamble to the current regulations. So this is something that I'm pretty much engaged in a very high percentage of my time with institutions around the country. And Susan Seitley of AVIC asked me to take a look at the amnesty provision that's in the bill. And I just wanted to take a second to just, suggest caution and maybe a little reflection on the necessity of that language given federal developments in the amnesty area and what's already out there, and the prospect that adding new language to the obligations that college universities deal with in Vermont on top of the federal changes may end up being more confusing than necessary. Amnesty as a concept is certainly something that, in my experience, college and universities in Vermont and across the country are very supportive of. There was a 2011 Dear Colleague letter that the Department of Education, the US Department of Education issued, where they encouraged institutions to have amnesty to promote reporting so that people would come forward and understand that the institution's position was, it's not your fault that you've been subjected to behavior that you're reporting to be sexual assault. Just because you were engaged in use of alcohol or drugs in violation of our policies, we're not going to pursue you for a policy violation. You should not hesitate to come forward just because that's an issue. So schools really started putting that in their policies back in 2011. I anticipate that if you were to look around the state at places like Bennington or Middlebury, Champlain, St. Michael's, schools I work with, you're going to see amnesty language in there already. When the 2020 regulations were created, the current regulations, they include a section, and your legislative council representative can scribble this down if you choose to, but 34 CFR section 106.71 is a section that the Department of Education labels a retaliation section, and it prohibits retaliation, including pursuing disciplinary action against a student for a code of conduct violation, so like alcohol and drug violations, for example, that do not involve sex discrimination or sexual harassment, or in this context, sexual assault itself, but arise out of the same facts or circumstances for the purpose of dissuading people from enjoying their rights under Title IX, which would apply not just to making a formal complaint, but also seeking supportive measures or which I need a no contact order. I want to shift from one residence hall to another. I want to engage in an informal resolution process, which is allowed by the regulations. So if someone comes forward now under the federal regulations that apply to every institution across the country that participates in federal financial aid programs, which is virtually all of them, they're protected from retaliation by the institution in the form of the institution going after them for a disciplinary violation like drug and alcohol, that sort of thing. The regulations already say that, where the intent is to keep them from engaging in Title IX programs. The current regulation also has a provision that says specifically, it's an exception, and you'll see this parallel in language that's in the bill, charging an individual with a code of conduct violation for making a materially false statement in bad faith in the course of a grievance procedure, meaning a disciplinary process, does not constitute retaliation. So it's accepted from this prohibition on retaliation, except that it's noted that a determination that a respondent, the person who's reported to have engaged in misconduct, was not responsible is not alone sufficient to conclude that any party made a materially false statement in bad faith. So that's the current state of the regulation landscape. In July of 2022, The Biden administration issued its own take on the Title IX regulations. It kept a lot of the language from the Trump administration's version, which is currently the law, and it changed some things. It kept the beginning part of that language about institutions are prohibited from going after students for a disciplinary violation if it's related to an incident but not sexual assault or harassment itself, like an alcohol violation. They left that part in. They took out the part about bad faith and relied on some more general language. And your Ledge Council can look this up, but there's a section in the preamble to the regulations. So the regulations are not yet final. They're undergoing rulemaking at the moment. They're likely to be finalized in May of 2024. But there's a preamble section that goes on for hundreds of pages, and page 41490 of the July 12th, 2022 Federal Register, it's volume 87, number 132, page 41490, has an analysis by the Department of Ed, the Biden Department of Ed, of why they changed the language, why they took out the reference to bad faith. And not to get too much into the weeds of it, I would just say that it would, if the amnesty provision as written in this bill were mandated as law in Vermont, institutions could end up confused into thinking that they could move forward in on a bad faith sort of prosecution or disciplinary process, and that wouldn't possibly implicate the federal regulation. The federal regulation gets changed the way the Biden administration wants it to. I assume it could be worked out if they called me and we all worked it out, right? But an institution that wasn't operating with counsel and aware of all these nuances could get confused into thinking that they have this permission from the legislature to do a certain thing in Vermont, could end up being different than what the federal reg says. And to complicate it all further, the federal reg's not final yet. We think it's going in that direction, but we're not sure. So I'll just end by saying, when, in my experience, legislatures add things to a state law that are close but not quite what the federal law is, it becomes very difficult for institutions to navigate that difference, because it's one thing to write a policy, it's another thing to provide it in a circumstance that's really important, obviously, to all of the parties involved. And it can get very complicated and very difficult to write policy that has all the different elements that are required by parallel but not identical federal and state laws. And I would say the same thing about Section 5, the training piece. This language is very close to what the Clery Act provides. There's a section 34 CFR 668 point, look it up, 668.46J, and I'm sorry to use all the lingo, it's just the way the regs are constructed. It requires institutions that are participating again in federal funding programs, so virtually all institutions of higher ed, to offer primary prevention and awareness programming to describe that in their, it's called an annual security report. The words aren't identical, however, between the regulation and the bill. And I just have to look at this and wonder, as I think about the work of Title IX coordinators and people that are going to be arranging for training on campuses, if they're already doing substantially the same thing, pursuant to the federal regulations, it's just going to add one more element in another 20 PowerPoint slides, but may not be more instructive to the students who would participate in programs to have slightly differently worded language. So that's just an observation on that. And if it would be helpful, I'd be happy to try to answer any questions that the committee has.
Any questions for Mr. Nolan? Mr. Nolan, it would be helpful if you do have some written testimony, or can create some written testimony. That would be helpful, just so we can have it on in front of us and review it in the next couple of days.
Okay. Will do.
Ms. Robinson, Ms. Koenig, Ms. Steitley, we're gonna have to come back to this tomorrow, so I'm afraid if you don't mind, you're gonna have to. We have to move, we have to vote on Thursday. It looks like, so you can all gather and hopefully come back and maybe have some agreement on subsection A. Ms. Robinson?
Happy to work on that. Happy to work on that.
Yep, we'll run it by.
Your counsel, I'm gonna say as well.
Yes.
Okay, anything else, committee, on this issue? And you, I'm sorry, Ms. Turner, you'll be involved as well. I apologize. Yes. Okay, I know there's a chairs meeting, and Ms. St. James, if you don't mind sticking around, we have some edits to the miscellaneous ed bill that I can show you. We can stick around.